I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I'm bringing you number 91 in our compilation series. Today, we're going to be in 3 different courtrooms, but for 2 of those courtrooms, we're going to be dealing with the same sovereign citizen. He actually went to court in the last few days, and I'm going to share his recent appearance here in this compilation. And before I give you the rundown on those judges, just want to say thank you guys always for joining me. Don't forget to like, subscribe, share, comment, whatever makes you feel good. Long as it's a good thing that you're doing, we're fine with it here at Sovereign Citizens Hall of Fame. Now, the rundown on those judges. The first judge's courtroom that we will be in is that of Judge Brett Buckley out of the state of Washington. Second, we will be in the courtroom of Judge Sam Meyer, also out of the state of Washington. And last but not least, we will be in the courtroom of Judge Erane, Washington, for one of our famous sovereign citizens, and she is out of the state of Michigan. And listen, without further ado, guys, I'm not going to hold this thing up. Let's go ahead and jump into number 91.
And Mr. Black, good morning.
Good morning.
And your criminal charge is dismissed on Friday, is that right? Thursday?
I don't know. Okay, well, thank you. How come I wasn't notified?
Well, that's not what you're here for today. You're here for the traffic infraction. That's what it's for. I don't know.
I thought this was a motion hearing.
It was going to be, but the state made a motion to dismiss your charge.
Okay. So now it's going to
So,
be contested.
Yeah, I'm waiting for your file to open up here. Sometimes our technology lags, so I'm waiting for it to give me access to your file.
I didn't come prepared to contest the infractions.
Well, that'll be easy because you can tell me whether you have insurance or not, but hold on a second.
Sure.
Let me just explain. Failure to transfer title, the trip permit, and the driving suspended charges, which are all criminal charges. And those are the ones that you'd filed all the pleadings on, which I've read all your pleadings.
Okay. You have any comments on it? Just curious.
I'll give you my comments here in a moment.
And I believe the police report states that I did produce my insurance, but it took me a while to find it.
Do you happen to have a copy of it with you?
Yeah.
Yes, you.
Should I approach
Yeah, please.
to the middle of the big paragraph? Oh, it's on the last paragraph.
Right. And do you have a copy of whatever you showed the officer by way of the insurance proof?
Yes. Oh, it's on my phone.
Yeah, that's fine. Do you have your phone with you?
Yeah, but I let somebody, one of my employees, take care of that. And he, whenever I need my insurance, I ask him where it is. But it'll take me a while to find it if you need me to.
Well, see if you can find it while I'm reading this.
Bringing it up.
Okay, great. Okay, so this is showing insurance for somebody, not you, for a car. I don't think it's the car it's identified here. Okay, it could be the vehicle. Who's Thomas Harris?
He's the employee that takes care of that stuff. He registers the vehicles, gets insurance for them.
And employee of yours?
Yeah.
And what type of business?
Biodiesel. I go to a gas station in Grand Mountain.
All right, and then the other thing to note here is that the insurance is purchased the day after the stop.
Yeah.
Yeah, look at 411. Stop was on 410.
Well, I can call. I'm sure it wasn't because when I called him, he produced this instantly. So I can call him and
right.
get it.
And you saw that, right? You saw that it said effective 411.
Let me take another look.
Yeah.
Thomas, you're on speakerphone. I'm in court right now. The criminal charges were dismissed, but the no insurance charge. Remember when I called you when the police stopped me and you sent me a copy of the insurance card? Well, the insurance card looks like it was purchased the day after the stop.
Oh, maybe it's just been the wrong one. Tell them that tell them we have a different insurance card. We got so many vehicles here, it's crazy. There's no way to get an insurance card that quickly when I'm working like that. The only thing I could do was send you some proof of insurance that I had in my phone.
Okay. Yeah. All right.
So what did they say?
Well, you're on speakerphone now. I'm in court, and
I mean, you got to realize we're working around.
How could this possibly be purchased the next day? You didn't purchase insurance the next day, did you?
No. What they may have done is what they do is they renew the insurance every 6 months or so. And what happens is it automatically prints out ahead of time. And so what may have happened is they give us the card in advance, and then I get it online, and then I just put them in my phone. But I got so many cards in there that it's hard to find them.
Okay, I think that explains it.
Okay, yeah.
Okay, well,
if you need me, I can look up and see where.
Well, let me ask the judge. Your Honor. Okay, that's all, Thomas. Thank you.
All right, thank
Bye.
you. Bye-bye.
Okay, so I'll find that the card you displayed is just the automatic renewal card that comes in. Coincidentally, it renewed the day after you got stopped, so I'll go ahead and buy that. Dismiss the ticket. I'll turn that to you. And then you asked me about your criminal charges. They were dismissed without prejudice. Now, without prejudice means they can be refiled.
Mhm.
So it's up to the prosecutor to decide whether they're going to refile them.
I prepared something for the court.
Yeah. Without the prosecutor here, I can't make any decisions. I'll just share some general thoughts with you because I see you've got a subsequent driving suspended ticket out of, looks like Tumwater. So you have a court date, I believe, in August on that. Let me check. So my guess is, since you have a new charge right away, that they may not be willing to dismiss the new charge, and they may resurface the old charge because, as I said, it was dismissed without prejudice, which means it can't be refiled. So right now you're scheduled for court on the Tumwater driving suspended charge on the 5th of August at 1:30 in the afternoon. So that's a Tuesday at 1:30. We're doing court. So without ruling on anything that might be filed on the new case, I'll just share some thoughts with you, which are that the view that you set forth in your pleadings is, we see that occasionally, very similar language. I don't know, sometimes the briefs we get in this line are all read the exact same. Yours is not the exact same, but a lot of exact same. There is no case in the country that says a state cannot regulate the driving, both commercial and private, on any public thoroughfare. So, I read your arguments as to why you believe the freedom of travel means you can drive your private vehicle on public roads, which are paid for by the registration of the vehicle, by the way, in part. That you believe you can drive because you have the constitutional right to travel. That it's never been interpreted that way. So the constitutional right to travel does not apply to overcome the requirements that states have imposed to require you to register your vehicle on an annual basis. That is it. I pay my registration fees every year because I have to, in order, if I want to put my car on the road. And I know if I put my car on the road with expired tabs, I'm going to get stopped and I'll have to pay the fine and I'll have to go get my car tabbed. I just know that's the way it works. And that's how the system is set up. So there's no legal argument there. You made it in a sort of a big way, but I think it's a misinterpretation of what you believe the right to travel is. It does not give you the right to travel in any state not adhering to that state's laws, and every state has a registration law like the state of Washington. So you've asked for my general.
Have you noticed that in courts, a car is referred to as a motor vehicle? Friend riding with you in the car is referred to as a passenger. You're engaged in traffic, and what the problem is, when a person registers his private property automobile with the state, he's declaring it a commercial vehicle.
No, that's your interpretation, and I'll just tell you that's not the interpretation shared by the courts. We don't see it that way at all. So the law makes very clear that all of us who have vehicles that we put on our roads, they have to be registered. Doesn't matter whether we have passengers, no passengers, if we drive them ourselves or not, if we're engaged solely in personal business or moving from point A to point B, none of that exempts us from the requirement to appropriately register our vehicles, which is used as a means of supporting the construction of the roads that we drive on.
Yeah, you know what? You said you've seen a few of these. What compels people to do this is the state abusing its power to license drivers, as well as doctors and other professionals. If you don't behave the way the state wants you to in your private life, in your family life, the state, through the family court, can have your license suspended. And that's just strong evidence that the system is not set up to make the road safe, but to control people. And people don't like that.
Yeah, no, I understand the philosophy behind that. We don't do anything here with suspending licenses or not. We just interpret whether the person has a license or doesn't have a license. That's the only rule of the court there. Now, I will say what you're referring to is the ability of the Department of Licensing to suspend licenses for the failure to pay child support as
It's
ordered.
government support.
What's that?
It's not child support, it's government support.
Okay, well, it's called child support. And that's what it's, if you look on your driving record, you have one of those things there that says, it says failure to pay child support. I understand there's a different way of looking at it. But it is not directly related to driving. I get that, but the legislature made that. They thought, how can we leverage people to pay what a court has determined they should pay for the support of their children? And they decided that one good way to do it was to leverage the ability to drive. So that's what the legislature decided to do. They created the law. Nobody has determined that law is unconstitutional.
A lot of people have, but they haven't taken it.
Right.
So in family court, the court rules don't apply. You know that. And due process is streamlined. So your driver's license can be suspended through a court procedure where it's a free-for-all. I've seen it.
Okay. Yeah. So I like I said, I understand the philosophy you're indicating. When the case comes to me on a driving suspended charge, I look to see if your license is active or if you don't have the privilege to drive on the state. And you view it as a right. The law views it as a privilege, and the privilege is enacted if you are properly registered and insured.
Well, it's a privilege to operate a motor vehicle on the highways, but the courts have ruled, and it's in my brief, it's a right to travel by your automobile, by your private property automobile.
There's no court. Like I said, you can look all you want, but nobody has ever found a case that says a court upheld the ability of somebody to drive in whatever state on public roads.
Well, driving is a commercial term too.
Okay. To operate a motor vehicle in any regard.
That's even more a commercial term. Look at it.
To operate your car. No, there's no case that says you can operate
means
your car.
Using a business machine on a public utility.
No, that doesn't. Operate means I'm operating my computer. I'm operating.
That's a colloquial.
My pencil.
That's a colloquial term.
Well, then you're pushing your example into sort
Look
of.
at Black's 5th edition. You'll see that operate means using a business machine for gain.
Okay. I disagree with that, and I don't think you'll find any case that supports that.
Okay, so I appreciate your input.
All right.
Thank you.
We'll see you.
Was Mr. Blatt here?
Who's here for court?
Then we may as well.
Thank you.
Yes, Mr. Blatt is here.
Oh, are you Wingtep TMRV? See,
I don't know what that is.
I don't either, but that's what you're identified for on the Zoom call. A lot of people can put their name in there, so I know who I'm talking to. Yours just says Wingtech TMRV.
This is really the first time I've used Zoom. I'm not familiar with it.
Okay, well, can you activate your camera so I can see you?
I'm trying to. This is a new phone, so I'm not familiar with it. I can't see anything where to activate the camera.
Well, go down in the lower left. There you've changed it. Oh, did you do that? Okay.
To start my video.
So on the lower left screen, you should have a little, there, I think you're gonna come on here in a second. Yeah, there you are.
You see me?
Hi there.
Okay, I don't see me, but
I see you. And did you mute him? No.
No, I didn't mean it.
Okay, so I need you to unmute Mr. Blatt. Click on your microphone. So Mr. Blatt, in the lower left corner, there's going to be a little silhouette of a microphone with a line through it. You need to click on that. I can't hear you until you do that. I can't hear you. You've muted your microphone. You need to unmute it. Still can't hear you.
okay, can you hear me now?
Yes, I'd like to be able to do both, hear you and see you.
Can you see me? Can you hear me?
I cannot hear you. I can hear you, but I cannot see you. I heard that.
Sorry.
There you are.
Okay, can you hear me?
I can. Can you hear me?
Yes.
Perfect. And I can see you, so don't change a thing.
All right, I won't touch it.
So there's a motion on the calendar here. You're representing yourself, correct?
I am myself.
I
I'm in
know.
propria persona.
I'm sorry?
I'm in propria persona.
Okay,
I
well,
am
in any
myself.
case, you don't have an attorney and you'll be running your own defense. Is that what you're
Okay.
telling me?
Yes.
Okay, and so the state's asked to, there's just a state, the city of Tumwater is asking to continue the trial. Did you see that motion?
No,
But
but I'll take your word for it.
thank you. But I will tell you what the substance of the motion is.
I have to explain if you missed the last hearing. I was poisoned by insecticide. I bought anti-flea spray for my dog, and it said non-toxic on it. So I sprayed it all over the house and my bed and my clothes, and it knocked me out for 2 weeks. And I still lose my balance sometimes. It was really poison.
Okay. I'm sorry to hear that. Here's where we're at on the trial. The state filed a motion. Let's see, right now, trial is set for confirmation is October 22nd, in 2 days. And then the trial is set for October 29th and 30th. The state's asking to move that because they have a witness issue. One of the police officer apparently is not available on that time. And so they want to move the trial maybe a week or two. And I guess I would get your position on that request.
Well, what'll happen if I decline that, if I object to it?
Well, then they're asking, then I get to decide whether or not the state has shown good cause to continue the trial or not. And then one of two things can happen, I guess. You're objecting, I can sustain your objection, not continue the trial, and then the state would probably be out of luck. Or I could find good cause because a material witness is unavailable, and then I can go a little bit beyond when speedy trial is to allow the trial to take place with the state's witness. And I can tell you a couple of things. One thing that this is a fairly common occurrence from both the defense and the state. And if a defense comes to me and says, hey, look, I need these witnesses to defend my case, but they're not available, can we move the trial? I'll generally accommodate that. I'll let people put on their defense, but the same is true for the state. If they have a witness, and I think who is material to their case, and they can't proceed without, I'll give the state some leeway to find good cause and reset the trial to when that witness can appear. So that might be a spoiler alert, but it's up to you. You don't have to agree. No one's asking you that. I'm just asking, I'm telling you what the state's asking. I'm telling you what generally happens in situations like this. And I'm just asking for your response, and then I'll make a ruling.
Okay, if you deny the prosecution's request, then the trial would be held in 2 days?
No, the trial, I don't know what would happen if they denied the state's request. Then if the state can't proceed, they can't. But I think
Okay.
I kind of hinted that generally I grant this type of motion, but because I want to be upfront with you. But it's
Yes,
up to you as to how you want to decide.
Well, I object to their motion.
All right. I'm going to find good cause to continue the trial because of the state's unavailability of a state's witness. I'm going to ask Ms. Kidmacher, when's the soonest available date that you can be ready and have a trial? And I'll set it for that date.
Your Honor, my understanding is the officer is unavailable through November 8th. Other than that, I don't have notes as to other unavailable dates.
So what we're going to do then, Mr. Blatt, We're gonna set the trial for November 17th and 18th. And then we'll have confirmation on, let me put these on November 12th, which is a Wednesday at the afternoon.
May I ask something?
Yes.
As I understand, the hearing I missed was the motions hearing, right?
No, this is the motion hearing.
Okay, I'm not prepared because, as I said, I was sick and I'm still recovering.
No, but the motion is, hang on just a second. The motion is to continue the trial. And I've already asked you what your response to that is.
Oh, so it's the prosecution's motion, but I also,
Yes.
didn't I also notice a motion hearing?
Okay, we can renote that if you want. I didn't see that. That's not
Yes,
what I'm
please.
here for here today. When did you ask for that motion hearing to be held? Oh, I see.
Your Honor, at the hearing back on September 3rd, I see a note for a motion hearing set for today. Defendant must file his motion no later than October 6th and.
Well, that was me.
state-
Yeah, did you ever file anything?
I don't think so because, like I said, I
Because you were
was
sick. I get it. Yeah, all right. Well, you're still free to, let's see. Well, do you want that motion heard?
Yes, please, but I'm not.
You better
prepared.
file it. I mean, you were supposed to file something by October 8th. We didn't get
Right.
anything.
Right. Can we reset that and the deadline for me to submit the motions?
Yes, we can do that, but we'll probably, in order to accommodate that, we're gonna have to move this trial out a little bit further.
Okay, past the speedy date?
Yes, it's already past the speedy date based on my
Okay.
finding of good cause because of the state's material witness unavailability. I can, at your request, if you want your motion heard before that, I'll accommodate that, but we're gonna have to mess with the dates a little bit.
Okay, I'll waive speedy trial rights for that.
Well, I don't even think we need to get there. I can make findings. Okay, so let's forget those dates. Let me redo these dates here. Well, let me ask you, how are you feeling now? How quickly can you get your motion together?
I'm doing okay. Like I said, I lose my balance sometimes, but I'm getting better.
I'm just asking you for a time limit. How much time do you need? I'll give you the time you need. I just want to know how much you need.
1 week.
All right.
1 week.
So hang on just today. Let me take a look here.
And Your Honor, I'm not sure what type of motion or whether it's going to be something that requires officer testimony. So I would just ask that it be.
My guess is if it's constitutional grounds, and if you need officer testimony, you can ask to reset it, but I
would ask that it be set after November 8th.
all right. Because the officers need to be
Correct.
present. All right, so we're gonna set a motion hearing for November 10th. All right,
Yes.
you need to have your motion filed by October 27th. It's a week from today, so you have a week to get your motion together. Get it
Okay.
filed by October 27th. The state needs to get their response in by November 3rd. And then the motion will be heard on November 10th. Why don't we just do a confirmation for that date also? And then I already moved the trial date to November 17th and 18th. We'll just leave that date. And then the confirmation will be the same as the motion hearing date on November 10th. And if he's successful, then we'll do it that way.
And you said trial 17th and 18th.
What's that? 17th and 18th. Okay, so do you understand where we're at?
Yes.
When do you need to have your motion filed by?
The 27th, 1 week.
Right. And then the state by the 3rd, we'll see everybody back here on the 10th.
Okay. Thank you.
Hang on just a second. I have another question for you. Have you been getting text reminders of court dates?
Yes.
Great. We'll see you back here, and then this will be excluded from speedy trial calculation. I'll make that finding based on the witness unavailability and to accommodate Mr. Blatt's ability to get his motion in. Understand all that, Mr. Blatt?
Yes.
You're free to go.
Okay, thank you.
Sure. So I think everybody else is a change of plea or a disposition of some sort, so we may as well go through them.
I can call Mr. Nicholas Watson. He's present in the courtroom with us today.
Who is he? Mr. Watson, come on up, please. So, Mr. Blatt, you're free to go. You can just hang up your phone.
I'm trying to go.
Good afternoon. The 14B District Court is now in session. My name is Erane Washington, and I'm the judge that will be presiding over the session. The court will call the case of Country Meadows Apartments versus Tariq Samar, Tarika Day, and Erica Witherspoon. Case number 23C0276.
Good afternoon, Your Honor. Christopher Borkin appearing on behalf of the plaintiff.
Hello,
Hello, Mr. Day. Please state your name.
I'm Tariq Smart Tariq Day.
Thank you, sir. All right, we're here today for a hearing regarding what I see as a non-payment of rent case.
Yeah, we just got a notice from the representative of the county because this apartment is in violation. I could send the email to Mr. Borkin. It's from building official designee Carcom. And it states notice is hereby do not remove under penalty of law. Notice is hereby given that this occupier rental property is in violation of provisions of the Property Maintenance Code and Rental Property Ordinance, Chapter 48, as indicated. Date and time 3/24/23 at 10:35 a.m. Notice to tenants: you are not required to leave this building, but you can put rent money in escrow until this posting is removed with permission of the ordinance enforcement officer. Contact legal services to learn more about this process. This further validates the reason why I issued the correspondence that I sent to you privately, as well as to Mr. Borkin, that Country Meadows has not held up their end of the contract and has been in constant violation of the contract. And I'm here today seeking a judgment in the matter.
Well, so you can't seek a judgment in the matter. That's not how that works. But I am hearing you when you say that the house, the apartment is not apparently up to code. We'd have to see that documentation.
The lady just left a few hours ago.
Okay. Mr. Borkin, I presume since the notice was just provided, you and your client have not received that, or are you aware of any of the information?
That's correct, Your Honor. This is the first I'm hearing of any notice.
That was the reason for the withholding of rent, along with the main issue, which I notified the management about, as well as Mark Landau and Mr. Borkin. I've issued what we are expecting to take place, and if it doesn't take place, then we'll be moving forward with our counterclaim in civil court. If I'm not able to do it orally here today, which I also validated, not validated, but also placed into the correspondence that I sent to all parties in the matter.
Sir, you have not filed anything entitled a counterclaim. Documents have to follow the court rules.
Well, it's in contrary to that belief, as I stated on our last call, I'm not a United States citizen.
Sir,
I'm a foreign
you
national.
don't get to use the laws when they apply to you and not use them when.
First and foremost, not to cut you off, ma'am.
That's exactly what you're doing.
Well, when I'm able to speak, I'll speak then.
Mr. Borkin, if there's a problem with the apartment, he's entitled to place monies into an escrow account. I have not inquired about what that escrow looks like or whether they're doing that or not. I think what we need to do first is get a copy of whatever documentation you were served with today, Mr. Day.
Okay. I don't want to take it off the door because it'd be against the law, but I can definitely, I took a picture and I can send it via email to Mr. Borkin. And if he wants to get that to your email or to the clerk's email, I don't have a clerk's email or your clerk's email, but I could email that as soon as we get off.
Can you email it to Mr. Borkin? You have his email address?
I do.
All right. Can you email it to him, please?
Yes, ma'am.
Your Honor, I would point out with this notice and any other notice, if rent is being placed into escrow, it's not something that my client has been made aware of. It's not something that's followed the Michigan law for placing rent into escrow. And I would just ask the court to take that into consideration.
Thank you. I want to review the documentation that we have here.
Do you want me to send it now so you can get it, or is this going to be scheduled out for? Oh,
I want you to send it now, please.
no problem.
While he's sending that documentation, is it true that the balance at this point is $1,083?
That is not true. The last ledger I received, it still shows a balance of $3,700.70. Correct me if that is not accurate any longer, but that is the latest ledger that I have.
Okay, thank you. I guess the other question that I have is, I know that you filed a host of documents with the court today, Mr. Borkin. Were those documents also provided to Mr. Day?
I did neglect to forward them to his email. That was completely my mistake. I'm realizing I can do that now. The only documents I sent was Mr. Day's lease.
It's just the lease. Okay.
But I also had questions in regarding to the correspondences that I sent. None of the claims that I put on record have been addressed by the plaintiff.
Mr. Day, I denied that motion when you were here last time. I'm not going to readdress it.
Excuse me.
It's not in your best interest to go down this road.
Well, are you giving me legal advice, or is that a threat?
I'm telling you that it's not in your best interest to go down this road.
And I'm asking, are you giving legal advice?
What is your point, sir? What do you want to say? That if you're still going down that road, what's going to happen is you're going to have a problem with your case. That's what I'm telling you.
So you're giving me legal advice?
That is not legal advice. I'm the judge. I'm going to make a ruling, and I'm telling you that it's not in your best interest.
Well, I don't agree, and I feel that I've already filed a.
I already denied that motion.
I'm not talking about the affidavit. I'm not talking about the affidavit. I'm speaking on your judicial capacities. I've already filed a complaint with the Judicial Tenure Commission in regards to how you're handling this case.
That's fine, sir.
So you will be under investigation for that. And I've also, as I've stated, I'm not a United States citizen. And
I'm not going to deal with that motion again. I already told you that does not apply here. You're going to be under the laws of this land. I'm done with that.
Excuse me, ma'am. The laws of the land is treaty law, which I'm under, which supersedes state legislature codes and statutes. I am, as I stated before, a foreign national, and I'm under the Constitution of the Moorish Natural Republic of Peace, which supersedes state law. And for you to continue to pursue the matter is a ultra-virus act. I am, as I stated before, a foreign national, and I'm under the Constitution of the Moorish Natural Republic of Peace, which supersedes state law.
Okay. Are you going to provide the documentation or not, Mr. Day?
Yes, I thought I just sent it.
I don't have anything in my email, Mr. Day.
Okay, hold on 1 second, sir.
Your Honor, while he does that, would it be possible for me to address the beginning of the time frame that he started withholding rent in this matter?
By that, are you meaning, can you ask him when he started?
Well, I believe it was in around November or December, and Mr. Day would.
January.
Around January of this year. Is that correct, Mr. Day?
January.
Your Honor, Mr. Day's counterclaim revolves around my client's use of cleaning chemicals in common areas. My client has made all efforts possible to prevent the cleaning company from using this cleaning chemical, but there have been a handful of instances that they have neglected to listen to my client's words, and they've used the chemical anyway.
When you say counterclaim, do you have something that I don't have? I don't have any document labeled a counterclaim.
Maybe perhaps I'm crossing a line here, Your Honor, a bit. It was unclear to me what was made on the record and what wasn't. In terms of a rental abatement that the defendant would be seeking, the basis would be steeped in repair issues. But I don't have that in writing. That's just been based on the discussions that I've had with Mr. Day.
I see. So the basis for the notice today, you're saying, is about cleaning products?
The notice from today is because of repairs that, along with the cleaning products, is the reason for the withholding of rent. The repairs. I'm sorry?
Lack of repairs?
Yes. These are things that I've been in contact with Country Meadows for since last summer in regards to the repairs that need to be made, in regards to the cleaning supplies being used. My wife is severely allergic to certain, well, mostly all kind of perfumes, chemicals, and things of that nature. Her throat will begin to seize up or close up, excuse me. And it's detrimental to her health. She's 9 months pregnant. Her water just broke yesterday. And the most recent time that they cleaned was at the beginning of the month, again, using the same chemicals, Fabuloso, which I have pictures and picture evidence of, and documentation of how Fabuloso has been recalled. All Fabuloso products have been recalled since last year, this year, continuing into this year and up until recently. So, as I stated to Country Meadows and Mark Lando and Mr. Borkin, that if the issue was not going to be addressed, then we will be seeking damages for our inconvenience and our inability to properly inhabit the property, and it is a violation against our enjoyments of being able to be here without worrying about health issues or repair issues or things of that nature. So yeah, I just emailed Mr. Borkin the citation or documents, I don't really know what to call it, from the Washtenaw County representative. So I mean, if he wants to give it, pass it on to Country Meadows, they're already well aware of it. This is just a finalization, I guess you could say, of the documentation that has already been put on the record in regards to our correspondence, not with me in the court.
So, have you received that yet, Mr. Borkin?
I have, Your Honor, and I'm prepared to address that when the court would like.
Well, I'd like for you to send it to the court, please.
I'm sending it now this moment.
And my question, the other question I have while it's on its way, is that from Washtenaw County or Ypsilanti Township?
It appears to be from Ypsilanti Township.
Yes.
Thank you. Mr. Day, I need you to take an oath at this time.
For what is this for?
If you're going to give testimony, you need to take an oath, sir.
Oh, okay.
Will you please raise your right hand?
As I stated, I will affirm to with you to take an oath. Yes, but I'm not a United States citizen, so I don't raise my hand or do.
So you're not going to take the oath, in other words?
No, I will, but just not as I'm not forced to assimilate to how you guys do things. That's
the way we do things is for you to raise your hand so you can make that affirmation. If you're refusing to raise your hand, then you're not making the affirmation.
Well, then that'll be a violation of the American Declaration of the Rights of Indigenous Peoples. I have the right to self-government. That is federal law as well as international. You, as a agent of the state, are required to make what is the word? You're required to make certain accommodations for foreign individuals in regards to the handling of court cases or court manners, or I'm not sure the proper term, but you're required by law, state law, federal law, and international law to accommodate me in my religious beliefs and my religious way of life. Because if you don't, that'll be a violation of my life, liberty, and pursuit of happiness. It'll be a violation of the Bill of Rights, Amendment 1, the First Amendment.
How do you, sir, think that you can bring up the Constitution and your rights under it at the same time that you say you're foreign and it doesn't apply? That's always been a question I have.
Well, the issue is because though I am foreign, the Constitution is the supreme law of the land to you. Not to me, but to you.
Oh, I see.
Yes, as I said, I come under the Constitution of the Moorish National Republic of Peace, which is a de jure government recognized as a de jure government. And that's the Constitution and the laws and the bylaws that I am under, and that that has jurisdiction over me. The court and the plaintiff have yet to prove subject matter jurisdiction or personal jurisdiction, and I've raised the issue. And it's been swept under the rug. It's not been addressed in a jurisdiction.
I denied your motion already, sir, several times.
Again, that wasn't a motion.
You know what? The reality is you don't like the ruling. That's on you. But that is the ruling.
And that will be a violation of your judicial code of conduct.
Okay, cool.
All
right. Sir. All right, I am reviewing this notice here from the Charter Township of Ypsilanti, which indicates that there are violations of provisions of the Property Maintenance Code and Rental Property Ordinance, Chapter 48, as indicated here. But I don't see any boxes checked. Mr. Borkin?
Yes, Your Honor.
Have you reviewed this documentation? You said you had something you wanted to say about it.
I have, Your Honor, and I have the same issue. I would question its validity, as well as its place in the hearing today, if it doesn't even have a violation checked. Potentially it's a notice, but it doesn't seem to be a notice of any sort of information about a violation.
Mr. Day, is there some part of this document that we're missing where there's a code violation box checked? Because I don't see one on here.
That's just what the agent of the township put on the door, and what she stated was that they're in violation, which I already knew. So,
Mr. Day,
I can't speak to that.
Mr. Day, as I look at this document, I'm asking you a simple question. Do you see a checkbox since it's simply a picture that I cannot see?
It may be. I don't know.
Okay. All right. Well, Mr. Borkin, my concern is that I think we need to talk to the Charter Township of Ypsilanti to make a determination if there is some type of violation. Are you able to call over there to see if you can reach someone?
I am. I could do that today if we could set this aside for just a moment.
All right. I'm going to pass this case.
Thank you, Your Honor. I'll do that right now.
We'll be on a brief recess. All right. The 14B District Court is now back in session. All right, we're back on the record in the case of Country Meadows Apartments versus Tariq Day and Erica Witherspoon, case number 23C0276.
Good afternoon again, Your Honor. Christopher Borgen appearing on behalf of the plaintiff.
Good afternoon. You're muted, Mr. Day.
Sorry, I'm Tariq Samar Tariqat Day, a citizen of heaven.
Thank you. All right, Mr. Borkin, were you able to reach anyone at the township offices?
I was, Your Honor. I called and spoke to two people at the Charter Township of Ypsilanti Office of Community Standards, and I did find that this notice is legitimate. However, having said that, and having reviewed some of the Ypsilanti ordinances, I can say with confidence that I don't think it's relevant for today's proceeding because my client still has the ability to charge rent even having failed an inspection. Yes, the notice does say that the tenant does have the ability to place rent into escrow. However, the result of failing an inspection or having a reinspection or the need for a reinspection only involves, for the purposes of the ordinance, a new certificate of compliance. It does not involve the landlord's ability to charge rent. My client does have a certificate of compliance. It continues to be valid. However, they do have a couple items to follow up on Mr. Day's property, but it does not affect the habitability. It does not give credence to Mr. Day's counterclaims, and I would still ask a court for a judgment today for non-payment of rent.
I understand what you just said, Mr. Borkin. However, my concern is you can say that they have the ability to charge rent, which they do, and he has the ability to escrow that rent. And I mean, whether you're disputing whether he's escrowing it properly or not is something I haven't addressed yet. But he's also, I don't know the nature of the actual repairs that have not been done, and they may get to the point where he's entitled to some type of an abatement. So I can't give you a judgment without knowing the nature of the repairs or lack thereof.
My request, Your Honor, would be to come back to court once my client is in perfect condition with the city. I understand the repairs that do need to be made are relatively minor. However, I believe the court's concerns are valid, and we should certainly not be pursuing a judgment today. Would the court be amenable to adjourning this until my client can resolve those issues at their apartment?
Mr. Day?
Yes, ma'am.
I do have to give you an opportunity to weigh in at this point. What would you like to say?
Well, first, I just wanted to go back just a second in regards to my statement or testimony being on the record. It's just on the record because I just wanted to make sure I was
on the record. You're not under oath, sir.
correct. So, okay, I think could you elaborate on that? I'm not comprehending. So is my testimony not valid then? Or
Actually, not right now. I'm not taking testimony from you. Right now, I'm trying to ask you what your position is with respect to their request to adjourn this to give them time to make the repairs.
Well, as I've sent my correspondences, and I said that you said that I wasn't able to seek a judgment, but had this notice not come up, then would you have allowed Mr. Borkin to seek judgment? Because
because he filed an action and he's entitled to a judgment in this case. You have not filed any action, and so therefore you can't seek a judgment.
Ma'am, my claim was a valid claim. I made valid claims to the property and to the trust property. I've made valid claims through my.
So there is no trust property, and I've denied that motion. So can you please answer the question as to whether or not you are going to dispute their request to have an adjournment?
I truly feel that I'm being discriminated against, and my rights are being violated. I've stated on the record that I have a right to self-autonomy and self-governance as according to international law and federal law.
You've said that over and over again. You've said you
Yes.
filed a grievance, and my position remains the same.
That you agree that you're violating, your actions are violating my
No, I
rights.
never said that, sir. What I said is your motion is denied.
But ma'am,
I'm not going to keep going in circles with you about this, Mr. Day.
and that's discrimination, ma'am. Is there, how could I'm putting a formal request for the transcripts of
You do that in writing. You've done that already. They've told you the procedure. You can do it for this hearing as well.
Okay, but that procedure is a forced assimilation. That's forcing me to assimilate.
Sir, you need to answer the question that I have put before you.
Well, under threat, duress, and coercion, since I'm feeling threatened, I'm under duress, and I'm being coerced into answering this question.
Okay.
I will answer the question, and I feel that, man, I'm feeling very anxious because this is I feel like I'm being discriminated against, and I don't feel good about the things, the actions that are taking place right now.
I understand that. You've made that very clear. That is why you filed a grievance. Nevertheless, at this point in time, the question before you is whether or not you're going to object to them having an adjournment today. All right.
Ma'am, I'm having a hard time right now because I'm doing what I know to be correct, and I feel I'm being
You don't,
motivated
but
for it.
you're all right. Mr. Borkin, how long will your client need to get the repairs together?
Your Honor, I believe a time span of 2 weeks would be sufficient. Cheryl, could you interject and tell me if that's not enough time?
Yes, 2 weeks is good.
Well, Mr. Borkin, we're not open on the 7th. That's Good Friday. Let's go. Are you available at 2:30 on Friday, April the 14th?
I would be, Your Honor.
Mr. Day, you need to be back here on Friday, April the 14th at 2:30, sir.
And again, I don't understand, how do you ask him if he's available, but I don't get that same courtesy? That's a
You're
discrimination.
not an attorney. That's not a discrimination, sir. You're a defendant in
Not
a.
being an attorney has nothing to do with my availability. And that's another reason why you are in violation of your judicial code of conduct. That's impropriety.
Okay. Are you available or you're not? And you're gonna say
I'm
no?
not available. I'm just like I wasn't available. I had to take off of work today.
Well, so you're gonna have to take off work. That's the point. He's an attorney and you're a defendant in a case.
And I won't be available that day.
Then you won't ever be available, will you? This always.
That's not correct. But I won't be available that day.
That's the day it's gonna be on, okay? You need to be here on April the 14th at 2:30, sir.
Thank you, Your Honor.
You're welcome.
I'm not threatening you. Say one more word and that's 30 days. 30 days.